I would like to just presage this with, well, post-stage it now. Only the presenters will be on the video. All non-hosting presenters will not be in the video, just so you know, oh, general audience.
And I want to welcome everyone again this evening. Thank you very much, Michael. I think Carlene is with us as well, I believe. And thank you very much, Carlene, for all of your great effort. Michael, you in particular, I want to say, as this is our last session, I want everyone to know this has been several years, and Michael and I have known each other a long time. Michael's been of tremendous value, not only to Hinda, but to myself and this legal panel, this legal course, now in our third year. Michael's added some not only great preparatory work, but also has asked very helpful questions during our Q&As. And I want to thank you, Michael, personally. You know how I feel about you, and it's, you know, you mean a lot to me, and I know you mean a lot to the organization. So thank you so much.
You're very welcome, and I really appreciate that, Dave. I think you're maybe trolling a little bit from Babka from the local Rebbitzin, whose cinnamon babka is pretty legendary, and I can do that. So,
well, thank you for everything. It's you've made my life a lot easier through this whole process.
It's been a pleasure, and I really appreciate your knowledge, your insights, and the information that helps so many people here.
Thank you so much. So many of you might know, maybe you don't, but I study Torah every week with Rabbi Shimon, and you know, that continued from my days in prison when I was studying with Rabbi Goldstein at FCI Milan, and I then met Rabbi Shimon when I was released, and I've every Sunday at between 10 and 11 in the morning we study Torah. In this week's Parsha, he and I discussed, and I thought I would discuss a little bit. I won't go in too much detail, but the spiritual meaning and significance of the tabernacle in Exodus. So, you know, what was the tabernacle in Exodus for? So God was very meticulous in how he wanted the tabernacle to be built and what types of materials were to be used for each section. Because of the nature of Hashem, each part of the tabernacle had a specific function because he does not waste anything, of course. What is the meaning of the tabernacle? Just in summary, and then I'll talk about the spiritual and symbolism. When God established the tabernacle, he was reminded by the people of Israel that his presence would always be with them. When we talk about and we think about, and when you look at the spiritual meanings and symbolism of the tabernacle in Exodus, it might lead one to ask, where is the tabernacle of God today? The good news is that what God told Moses is still true today. If you make God a sanctuary, he will dwell in it. Where is the sanctuary? You are the sanctuary and the place where God's Spirit dwells. I thought that was very well put by this writer here, so I wanted to read that verbatim, actually. I'm very pleased to be able to present myself tonight. I've been moderating this series of sessions primarily for these 3 years, but I'm going to speak tonight to several issues that I happen to be involved with on behalf of many inmates who I work with through Hinda, but also independent of Hinda. I was incarcerated for 11 years federally. I am an attorney by background. I practiced law in the Northern District of Illinois for over 15 years. I was a civil trial lawyer, but then during my 11 years in prison, I became well-schooled in criminal law and did a lot of work for inmates while in 3 different federal prisons during those 11 years. I'm going to speak tonight to several issues of note of recent vintage relating to compassionate release developments, and there have been many, and particularly 2 different areas of 2-point sentencing reductions. Those of you who are familiar with the federal system understand the difficulties of breaking through and making progress with these the federal sentencing guidelines. I'm going to speak to that a lot this evening. We're also joined by 2 very esteemed speakers who work along with Alan Mills, and you may have been with us at the earlier discussions where Alan, one of our esteemed speakers for many years. And I'm going to introduce briefly Ashley and Maurice. They're going to speak immediately after I conclude. Ashley joined UPLC in September 2022 as a staff attorney. Her work focuses on tenants' rights and the Just Housing Amendment. She coordinates Know Your Rights training and community meetings with low-income tenants in Chicago. Ashley graduated from the University of Michigan Law School in 2022. Welcome, Ashley. We also have Maurice Hughes this evening, who joined UPLC in May 2023. Maurice returned home in April 2022 after 27 years in prison. Maurice is a deeply passionate person in helping others. Since getting out of prison, much of his focus has been spent advocating on behalf of those still incarcerated. He is a graduate of Future Leaders Apprenticeship Program, which prepares formerly imprisoned people for employment. In his role as outreach coordinator at UPLC, Maurice focuses on outreach and education for the community and on issues surrounding housing rights and discrimination. Welcome, Maurice. My name is David Grosky, as I mentioned. I'm a 1983 graduate of the Indiana University Kelley School of Business and a 1986 graduate of the Chicago-Kent College of Law. I was a member of the federal trial bar for the Northern District of Illinois from 1987 to 2007, practicing exclusively in civil litigation. During those years in private practice, I also specialized in complex business bankruptcy and commercial litigation matters. I'm currently employed as a sales development manager at Visiplex in Buffalo Grove, Illinois, where we are a global leader in emergency notification, wireless system equipment, and installations. I devote much of my time and energy on a continuing basis where I can, assisting inmates in both federal and state prisons in a variety of different legal matters, but most prominently in post-conviction appellate matters. And I'm going to be speaking about some of those issues this evening. So welcome, everyone, and I'll begin with, and by the way, as I go on, and as I think, and Ashley and Maurice speak as well, all of you can feel free in the chat or otherwise to ask questions as we move along. There's no such thing as interrupting. You can ask at any time, and I'd be very pleased to answer any of your questions. Let's begin with a brief discussion of compassionate release in the federal system. There's been a lot of progress of late, and at least in my view, after in April of 2023, the Federal Sentencing Commission made certain amendments to those sentencing guidelines, making it a little bit more user-friendly for those who want to file compassionate release motions. In particular, those who have medical conditions that they can establish through evidence, typically through an outside physician, establishing that the care that they're receiving in prison, in federal prison, is not up to par with what they'd be receiving if they were home on home confinement. And that generally relates to what would be defined as chronic conditions. If an individual is suffering, for instance, from high blood pressure or high cholesterol, and are on medication and being treated for that, and those particular issues are under control, generally that's not going to suffice as a practical matter alone to be able to receive compassionate release into home confinement, early release into home confinement. On the other hand, if someone has a chronic condition like asthma, I happen to have a client now that I'm assisting who's in Terre Haute camp, and he's got a breathing problem. He's got a very severe asthmatic and respiratory issue, and he's not getting breathing treatments. And he almost went into a coma. He came into a very difficult situation where he couldn't breathe at all and was rushed to the hospital. He received the breathing treatments, came back to the prison, and since then has not been receiving his breathing treatments regularly again. I have now filed an emergency motion for this individual, asking for immediate release into home confinement based upon this new standard that says that, again, if you can establish through medical expert testimony, if you will, or a letter from a medical professional, that the care you'd be receiving while on home confinement would be materially different and better and more meaningful than what you're receiving in prison, that alone could be grounds for early release to home confinement, where historically, the only way based upon a medical issue of yourself that you could, as a practical matter, be released early would be if you can establish with a reasonable degree of medical certainty that you have 12 months or less to live, which of course is a very difficult standard for many people who are suffering from chronic conditions but may not be near fatality. So that's one area. The other area there's been movement is on the assistance to family members. Historically, it was only immediate family that an individual could, if an inmate can establish that the immediate family, defined as children or a wife for a man, or in the case of a woman, of course, a husband, could establish that an individual within the immediate family was not able to have proper care on a day-to-day basis of a very difficult medical condition, such as cancer, heart ailments, etc. That it would have to be an immediate family member that it would have to be established would need the care of that particular inmate to be released early to care for that individual. That has since expanded to the inmate's parents as well now. And that's a much more common scenario, of course, because of elderly parents and the needs of the elderly parents. So I've had some good success on this of late, filing on behalf of several inmates who have parents who either the inmate does not have a sibling who can care for the parent, or that sibling is no longer able to care for the parent, and we can evidentially establish that only the inmate, and that's the standard, only that inmate could care for that particular individual, both from a financial perspective. The parent cannot afford care outside of the family, and there are no other family members who can care for that particular parent. So that's become, a way for several individuals that I'm familiar with to be able to get into home confinement early. And I am seeing, I have to say to all of you, and again, in the federal system, there's been a very meaningful movement of the government, when I say the government, politicians, the Congress, and of the Sentencing Commission working in tandem with Congress to begin to move more aggressively to change the laws or to modify to be moving people more commonly into home confinement early. During my days, I can tell you, there was almost no one in home confinement more than a year or two. And now I'm seeing, in the aftermath of COVID and then with some of these amendments, many, many inmates in the federal system now, I'm seeing on home confinement for 5, 6, 7 years. And while that still is challenging, of course, it beats being in prison. So that is very promising to me, those type of movements. And this was something that during all of my years in prison, I saw absolutely no movement. It was very depressing. So it's very encouraging to see this, I have to say. And I think that's going to continue. So that's my discussion on compassionate release. Does anyone have any questions on the federal compassionate release discussion I just had before I move on to the 2-point reduction? Okay, if anyone has any question, you can ask at any moment, of course. With respect to the 2023 federal sentencing guideline amendments with respect to the 2-point reduction, there are really 2 areas where for what I would call fertile ground for the 2-point reduction. One is for 0 criminal history point offenders, and the other relates to those who were sentenced who were not 0-point criminal history offenders. However, they were offenders who were sentenced while on probation or parole for another offense. And both of these categories of individuals are subject to a 2-point reduction, which many times can lead for up to a 2-year sentence reduction if successful. The most fertile ground, I would say to you all, is where those offenders who have 0 criminal history points. And who are those generally? Those are offenders who have never committed a federal offense in the past, such as myself. I was a first-time offender. Of course, I was out of the system, so this did not benefit me. But using me as an example, someone who had a white-collar crime, because there are exclusions for certain offenses, such as sex offenses, unfortunately. But if you have a drug offense without an involvement of a firearm, or you are a white-collar offender, this is fertile ground for attack on a 2-point reduction motion, I can tell you. And the only way to be defeated on it is a practical matter. If you had 0 criminal history points and you had one of those type of offenses, would be if you're not performing well in prison. For instance, you were committing, different types of disciplinary infractions while in prison, that the judge, who can always use what they call the 3553 factors, which is a consideration of your performance while you've been in prison, could ultimately lead a judge who still has discretion on these matters to say, I'm not comfortable with this person receiving that type of sentence reduction. I'm either going to give him a shorter one or none at all because of the poor performance in prison. So it's not automatic. I want to be clear, but if you have one of these type of offenses, such as a white collar or drug offense without the involvement of a firearm, you have a very good opportunity to proceed with what is called a 3582 sentence reduction motion. And I'd be very happy to discuss with any of you this offline if you'd like to discuss it in greater detail. The other example I gave of a opportunity to be able to receive a 2-point sentence reduction would be where one is sentenced while on probation or parole. That, though, is a little more complicated because then the question becomes how many criminal history points that particular individual had at the time that they were sentenced. And if you were a repeat offender with 7 or more criminal history points, you can only at most get 1 point reduction and oftentimes none. So, and if you have 2 or 3 points or less, you have a greater chance of getting a 1 or 2 year reduction. So it's a little more complex. I've provided Michael, who's provided, I think all of you with an ability through an attachment to read all of this. And again, I'd be very happy to discuss with you the particulars of particular case scenarios to determine whether it would be opportunistic to try to file this type of motion. I'd like to conclude with a brief discussion too of something that wasn't on my agenda, but I thought it's important. It's been discussed during my sessions in prior years, and that is the ability, whether you are in Illinois or not, to expunge or seal a state court conviction. As many of you may know, it is not possible to seal or expunge a federal court conviction. It is not possible to expunge, I should say, a federal court conviction. Sealing, difficult too. It is potentially possible under certain circumstances. However, with state court convictions, and I want to also say that if you are involved in the federal system and you have a significant federal criminal history score because of many past state criminal case convictions, it behooves that individual to look at getting those state court convictions expunged, because if successful with those expungements of the state court convictions, you can go into court subsequently and retroactively be repositioned with respect to your criminal history score and then benefit from some of these newer amendments, such as the 2-point reduction. And that's how I've counseled many of the inmates of late. And I'm working on certain state court expungement for several right now to be able to take advantage of the federal 2-point reduction. But what does it take to expunge or seal? So I want to briefly go through those requirements. In order to expunge, eligibility in Illinois, which is basically the law throughout the land, I have to say to you, is that you have to have been convicted of a crime that was you were convicted. Let me just take a look at this listing here. I'm sorry. Yeah, let's put that on the screen, Michael, if you can, for the, oh, you don't have that, I don't, or do you? Yes, you do. I'm sorry. Thank you very much. No, this is actually on the 2-level decrease. Yeah. I don't think you actually have this form on the criminal expungements and sealing. So let me kind of read through them then. Not all criminal records are eligible for expungement in Illinois. Generally, to qualify for expungement, you must not have any pending charges. This is probably the largest one, and misunderstood. Many people come to me, for instance, and want to have a state court criminal case expunged. You have to have completed your current case, whether it's federal or state, in order to apply for the expungement. That's true in Illinois. It's generally true in all states. The arrest did not result in the conviction, and no criminal charges are currently pending against you. That was my point there. You were convicted, but the conviction was later reversed or vacated. You were convicted, but later received a pardon from the governor specifically authorizing expungement. You received a sentence of qualified probation, and at least 5 years have passed since completing the period of probation. You have received a sentence of court supervision in a case involving charges of domestic battery, criminal sexual abuse in which the victim was over the age of 18, or operation of a vehicle that was uninsured, and at least 5 years have passed since the completion of the period of supervision. You received a sentence of court supervision for an offense other than those listed above, and at least 2 years have passed since the completion of the period of supervision. These are the basic requirements for expungement. Now, eligibility for sealing does not, well, let me digress. Expungement means if you succeed on expungement, it is gone. It is absolutely erased from the record in its entirety. While sealing, it's the offense still exists, but it's not open for viewing by public eyes, if you will, for public viewing. So for sealing, a broader range of criminal records may be sealed, except for certain offenses such as DUI, reckless driving, domestic battery, violation of an order of protection, crimes that require one to register as a sex offender, and animal offenses such as dogfighting. If you had previously, and this is again in Illinois, previously been convicted of a felony and had that conviction sealed, subsequent felony convictions will not be eligible for sealing, and sealed convictions may be unsealed. To be eligible for sealing, you must not have any pending criminal charges or be on active probation or parole or supervision. Once again, if any of you have any questions relating to expungement or sealing, whether it's in Illinois or another state, I'd be very happy to send you information on the state of your choosing relative to the requirements for that particular state for expungement or sealing. With that, I'd like to then turn to our guest speakers this evening, if there are no questions for me at the moment, and we could begin with Ashley. Ashley, if you'd like to begin with any visuals of any slides, Michael could assist you with that. I'm turning over at this point the further discussions to Ashley. Ashley, welcome again.
Thank you so much. Yes, if we're able to get a slideshow up, that would be great. I can share it from mine if we enable screen share, and I also believe you have a copy.
Okay, I will be sharing that.
Perfect. Thank you so much. While we're getting that up, I'll just quickly reintroduce myself. Again, my name is Ashley. I'm an attorney at Uptown People's Law Center. I'm joined by my colleague, Maurice Hughes tonight, who is our outreach coordinator. And we are going to be talking about the Just Housing Amendment, which is a Cook County specific law, but also briefly about both some federal and state level similar laws. So we can go ahead, go to the next slide. So I wanted to briefly put the JHA in context of fair housing generally. So fair housing is basically just the right for people to live where they choose. And for a fair housing law to be violated, generally you need two separate parts. You need to have someone in a protected class, and you need to have a prohibited act of discrimination. We can go on to the next slide. So we are all part of protected classes. We are all part of many protected classes, and the protected classes change based on what law you're looking at, what state you're in, what county you're in, what city you're in. So here I've used Illinois as an example. I've listed the Federal Fair Housing Act protected classes, which you can see, there are 7 or 8 of them. The Illinois human right protected classes, and there are significantly more, plus the federal protected classes. And then when you get a little bit more detailed down to the county level, Cook County actually has even more protected classes. And I've highlighted that the Illinois Human Rights Act has an arrest record, not necessarily any conviction records as a protected class, but they have arrest records as a protected class. And then you'll see in Cook County that covered criminal history is a protected class at the county level here. Move on to the next one. So like I said, there is no federal protected class for people who have arrests or convictions, but what we do have are some movement, I guess, in the HUD guidance and rulemaking area. So I wanted to briefly review that for all of you. So in the spring and summer of 2022, HUD was undertaking an evaluation of its policies to see what barriers there are for people who have records and what the implications of that are. And they released a finding in June of 2022 that actually some criminal background screenings might violate the Fair Housing Act. So that's the federal law. And they put housing providers on notice about how to potentially avoid these violations. And a lot of those had to do with using a background screening as a proxy for screening for race, which is a protected class. And then in 2023, so last spring, the HUD announced a plan to issue new guidance. This is a very federal government thing, right? They're announcing a plan to issue a statement to issue another plan, but it indicates that they are thinking about this and they're moving in a positive direction here, where they're planning to issue guidance so that people who have records and are being denied housing because of that face fewer barriers. And they released in October of last year a rule. So the rule is not published yet. It still has to go through a comment period and some revisions, but they've basically proposed a draft rule that outlines certain practices that they say prevent people with records from accessing either publicly funded housing or project-based subsidized housing. And those mostly have to do with things like the background check screening or tenant selection criteria. So there is a rule in the works. It has not been finalized yet, but people in our space are a little optimistic that there might be some positive movement here. And then I also wanted to throw in that at the same time, they proposed a rule to remove a restriction for fair housing testers. So for example, in Cook County, we have this local law that prevents discrimination against people with convictions, but federal fair housing testers aren't allowed to have convictions. So that's a little counterintuitive that we've got this law, but we can't use testers to actually test for it. So we're really hoping that that rule goes through. We can go to the next slide. So this is briefly what I think David was hoping I would address. There are many state and local rules about housing for people with arrests or convictions. Too many to go over in such a short time, but I wanted to pull out some examples of some patterns that we're seeing about how localities are legislating around this. So one thing that we've seen are look back periods. So that basically means that if after, for example, in Chicago or Cook County, we have a 3-year look back period. Anything older than 3 years shouldn't be considered in the housing context. Tenant selection criteria, there are a number of housing authorities in different states that have promulgated some guidance about what is and is not okay as tenant selection criteria. And so that has to do with how you are evaluating someone who has a record, how you are looking at somebody's application. And so that is another way of tackling this kind of discrimination. And then there are certain ways to address violations of certain local laws about pertaining to housing discrimination. So an administrative complaint, which is what we have here in Cook County, means that you don't have to file it with the court. You can actually just file it with a separate administrative department and say, like, you should find that they discriminated against me. You don't actually have to go through the process of the civil court. The private right of action is the opposite of that. It means that you do have the right to sue somebody in court for this housing discrimination. And then government action, our neighbors to the north here in at Evanston, they actually have in their city a ability to take government action if they notice a pattern or practice of landlords discriminating against people with records. If they have that evidence, they can actually bring a discrimination case themselves as the city. They don't necessarily need a client. Can move on to the next one. Okay, so now I am going to talk about the Just Housing Amendment, which is the Cook County specific amendment. Again, I know that not everyone on this call is in Cook County or is even in Illinois, but I hope it's a useful model to, if you are in contact with people who are organizing in your area, or just a way to think about it, or to, a framework to refer to. So the Just Housing Amendment, or the JHA for short, was passed, came into effect in February 2020, unfortunately, when a lot of other stuff was happening in the world. But it is an amendment to the Cook County Human Rights Ordinance that prohibits discrimination against people with arrest or conviction records. We can move on to the next slide. And at this point, I'm going to turn it over to Reese, who is going to talk a little bit about the impact of the JHA in the real sense and not just the legal jargon sense.
Good evening, everyone. Yes, my name is Maurice, and I want to speak about who the JHA is for. Someone like myself who served 27 years in IDOC. When I came home, I never knew about this law, first of all, when I was incarcerated. But since being home, I learned about this, and I definitely find that it is very helpful for those returning citizens, because one, I ran into a roadblock when I first came home. I don't know if everyone on this call know, but here in Illinois, like once you are released, you depending on the case, the crime that you was incarcerated for, there's this thing where you have to register upon release, and there's like 3 different type of registries, I believe. And for like someone like me who has served an extensive amount of time, not everyone who does that amount of time has family on the outside or somewhere to parole to upon release. And for me, fortunately, I did have that situation, but I was released to my parents' home, and then upon me trying to register to do what I was supposed to do, I ran into these roadblocks, and end up that turned into a situation where they notified the landlord, which was already discussed. And long story short, I ended up having to move again. So I ended up having to move to my brother's house, which was a great thing because he owned a home, so they really couldn't say anything about that. But I think it's so important for a law like this to be in place because, one, if someone is coming home and they're trying to get put their life back together, housing is a huge part of that. It provides stability. And then, as we all know, there's so many things to where you need to have an address or somewhere for, to receive mail and things like that. And then there's the other aspect of the family where, like in my situation, my parents being elderly, that would have been, I could have been there to be in support, to help, them do things around the house. So, there's the family aspect to it, and then the community part where, like, me being passionate about wanting to come out here and do things to give back and help those that are still incarcerated. There's the community part of it too, whereas like when those type of setbacks, it can discourage some people. Sometimes it can send people back down a spiral of where they feel like it just ain't no chance for them. So me seeing the connection of the housing part and helping us make it a smooth transition for those of us returning home. So that's who the JHA is definitely beneficial to an individual like myself. So next slide.
Yeah, so now I'm going to talk. Thank you so much, Reese, for giving some of that important context. And I noticed some great comments in the chat as well. That yeah, this law affects people, and I often get kind of lost in like the intricacies of it. And I'm so glad that we're able to take some time and think about the actual implications to people's lives of this policy. So with that said, now I'm going into the nitty-gritty policy details. So the law makes it unlawful to discriminate based on an arrest or conviction record. So that means a couple of things. There are some things that landlords are just outright not allowed to do in Cook County. And before I get too carried away, I do also want to make a note that the JHA applies pretty broadly, but unfortunately there are still some exceptions. And unfortunately, one of those exceptions are people with sex offenses. So and I know that that is a population that really needs this housing protection, but unfortunately they were excluded from this law. So none of what I'm about to say is going to apply there. The other, I think it's not common, I've never come across this, but the other exception is a federal prohibition on people who have been convicted of, I believe, manufacturing methamphetamines in public housing. That's a federal exception, but it's very, very niche. But with that out of the way, everyone else, the landlord cannot say something like no felonies or no criminal record in the ad. They can't refuse to show somebody a listing or change that listing, like change the rent when they find out somebody has a record. They actually can't ask anything about criminal history until a certain point in the application process, which I will walk us through in a later slide. But if you're just touring an apartment or if you are handed an application, they can't ask you something like, do you have a criminal record? And in fact, there is a part there that says, you can't have a checkbox on the application. That's something, unfortunately, we see a lot, but that's no longer, supposedly no longer allowed in Cook County. Move on to the next slide. So this is my visualization of the new application process that the JHA has created in Cook County. So there are a number of steps, and if the landlord does not follow the correct procedure, that is a violation of the JHA. So that's something that I always like to highlight, because I think that if other laws in other communities across the country want to write something similar, I think this is a very good model of doing it, because as an advocate, it is very, it's a lot easier to just show that a landlord has not done a step rather than having to show bias or having to show, that they meant to discriminate against somebody. It makes it a lot easier for people to bring these claims. So with that said, there are first some standard disclosures that they have to make before an application, accepting an application fee, and those include information about the Cook County Commission on Human Rights, which is the place that adjudicates these claims. Then you fill out your application as normal. So you put your pay stubs, you do your credit check, all of that stuff as normal. The only thing that's different about the application is they cannot say anything about a criminal background check. And then at that point, if everything looks good, the landlord can tell you that you are pre-qualified. And what that means is that unless there is something that they can deny you on based on the background check, which we'll get to in a moment, you have the apartment. So in other words, unless there is something that they can deny you on, which is like a very, very narrow subset of convictions that they can even consider, you should be good to go with your application. And this has basically just removed the background check from everything else in the application to prevent a situation where you apply, you look good on paper, they run a background check at the same time as everything else, they see that you have a conviction, and then they go, oh, well, actually, we're not discriminating against you based on your background check, but your credit score was not right. So it's really trying to prevent that situation where they have to say, like, look, everything else looks good before they have to consider the background check. So then they do the background check, and then there are a number of things that they have to do with that. The first thing is they must give the applicant a copy of the background check. They have to do this within 5 days. This is very important because you can see exactly what they're looking at. Sometimes the information is not accurate. Sometimes things that should not be on the background check show up anyway. Sometimes, it could be the wrong person. It is so important to have a copy of that background check. So if something happens, you can see what the landlord was looking at. Then you have an opportunity, once you receive that background check, you have 5 days to dispute something on it. And this can look different in different contexts. It can be as simple as, I want to highlight the fact that everything on this background check is older than 3 years, and so it is outside that look back period. Or it can be, this is not the correct person, this is not the correct background check, or it can be giving context. For example, one of my colleagues had a client who had a conviction for trespassing, but the story was that she was unhoused and it was Chicago in the winter, and she broke into somebody's garage because she was cold and she wanted somewhere warm to sleep. So, in that situation, she should have been given a chance to explain what had showed up on her background check. I'm going to pause here and talk about the 3-year look back period in a little bit more detail because I've talked about it, but I want to just explain what I mean by that. So in Cook County, the JHA created this 3-year look back period. And that means that anything older than 3 years should never be considered in a housing application. And that is the same thing for misdemeanors. That is the same thing for felonies. Everything except, unfortunately, sex offenses is treated the same. With recent things, so with, I guess at this point, it would have been February 2021 and on, if there's a conviction, the landlord can consider it. And I'll come back to that in a moment, but only within that 3-year period. And then things that are not convictions cannot be considered. And that's really big because many things show up on background checks that are not convictions. So that's charges that never were completely prosecuted, juvenile convictions, expunged or seals records, participation in a deferral or diversion program. I'm sure I'm forgetting a few, but there are many things. Oh, just arrests. Those things that show up on a background check that do not result in a conviction should never ever be considered. So, those are things that a housing provider should not ever deny someone based on. The other important part of this is that the 3-year look back period starts on the date of the conviction and not a release date. So that means that if you are coming home, you came home 2 weeks ago for a conviction from 1997, that is already way outside the look back period. And the JHA already protects you because it's about the conviction date and not the release date. I have got a really good question about parole. So often, the conviction date will probably be 3 years, more than 3 years ago if you're out on parole. And in that case, yes, absolutely, the JHA still does protect you, and that conviction should not be considered in your housing. So now we're at the dispute process, and I mentioned that there is that narrow slice of the conviction in the last 3 years. So let's say there is a conviction from March 2022. The landlord can consider that, but the only reason they can deny an applicant because of a recent conviction is if they can show that that particular conviction shows a demonstrable risk to the people or the property. So David mentioned white collar crimes. That would be very, very difficult to explain how that poses a demonstrable risk to the property or the people on the property. And what the law does is make it so the landlords cannot deny someone unless they go through a written individualized assessment, which analyzes exactly how that conviction poses a demonstrable risk and produces a written denial. And so if they have to go through all of these separate steps in order to actually, they can still deny a person based on a conviction. But the way I think of it is they're throwing up not roadblocks, but speed bumps, shall we say, so that they're not automatically denying people based on something that's on their background check just because there's something on their background check, right? There's, moments for them to pause and think about why they're actually doing this. And I think that's important. I think I see a question in the chat. So for those convicted of sex offenses, do you or similar organizations coordinate with others like Illinois Voices? The carve out seems broad since sex offenses covers such a wide swath of crimes/behaviors. The answer, yes, completely agree with you. I actually did not even realize how wide a swath that was until I started this work. We work and are continuing and hoping to continue to work pretty closely with an organization called the Chicago 400, which is a coalition of individuals who are on the registry in any registry actually, but most of them are on the sex offense registry in Chicago, and they are fantastic and very, very well organized, and actually recently came to one of our JHA enforcement meetings to talk about their experiences and some of their policy advocacy work, which we're hoping to support. And we're always happy to, build connections with other organizations in the city and the state. So if anybody has contacts, please feel free to put us in touch. So I won't get too into the weeds with this, but I have also been kind of trying to think of so the exact language of the JHA. There is because of the way that sex convictions work in Illinois, unfortunately, most people who have been convicted are required to register. The language of the JHA applies to people who have to register based on a sex offense, but there is like a very narrow group of people who were convicted before those requirements took place. So they have a sex offense, but they are not required to register. In that case, we think, I've done a lot of research, we think the JHA would apply, but unfortunately that is such a small category, and it, otherwise is not that helpful to most people who are dealing with housing insecurity because they have to register, which is super unfortunate. And I feel like I probably don't have to get into why that is such a failure of public policy. But to answer the question, I'm not familiar with that exact organization, but we do work with the Chicago 400, and we're always looking to expand the groups that we work with. We can move on to the next slide. Okay, so briefly, I just want to talk about what to actually do if the landlord has violated the law. So there is, as I mentioned, an administrative process. You file with the commission investigates the claim, and if they find that there was a violation of the law, they can award damages to the complainant, so the person who was denied housing. I will be honest, it is taking a really long time because the commission is deeply understaffed right now. So we've been really working with clients to find something that's appropriate for them, because sometimes clients just do not have the luxury of time. They need housing. So we'll settle these cases. But something that we've been able to do is sometimes we're able to settle cases, not just with damages financially, but also by providing housing for those people. Another thing that we are exploring and haven't fully delved into yet, but we are excited to do in 2024 is just exercising the individual right of action. We do have an individual right of action built into the JHA, which means that it can be adjudicated in circuit court. And at this point, we think that might be faster than the commission. So we are looking forward to working on that. We can go to the next slide. I'm going to kind of speed through this because I want to make sure to leave time for questions or comments. But I wanted to talk really briefly about some of the benefits of this law that I've seen. The first is that people who come to us often need housing, or they need resources to find housing, and the JHA allows us to do that. So even though we don't necessarily file a complaint for every case, the fact that we have the power to do that and the commission can award these pretty substantial damages means that we can pretty successfully negotiate with landlords. And so that is really helpful to our clients. They can get money if they need it. Another thing that I briefly touched on is the balance of the power, right? The landlord is the one with the burden to follow the law. The burden is not on the person applying to show that they've been discriminated against, and that does make a big difference. And then this last one is a little bit abstract, but I always like to mention it because as a lawyer, it is something I'm trying not to take for granted. The experience where someone comes to me, has a problem, feels like they were wronged, and I can say, the law agrees with you. You were wronged, and here's what we are going to do about it. That is something that I get the chance to do with the JHA very often because they're pretty clean cases, and that is something that I think is important, even though it's not tangible in the way that damages are. Go to the next slide. Talk about the challenges briefly. I mentioned already the time it takes to investigate these claims. That is, I would not be patient either. There's also a statute of limitations of 180 days, which is about 6 months. And sometimes people don't make it to us before that time is up, unfortunately. It's also new, so that means there are a lot of unanswered questions about how it works, like exactly what I call them edge cases it applies to. Like, for example, we're pretty sure it applies to nursing homes based on the way the law is written, but we don't actually know for sure. And that will come with time. And then finally, I'm going to let Reese chime in here and talk a little bit about some of our challenges with outreach, because one of the challenges we found is just a general lack of awareness of this law. And we've been trying to do some outreach to raise that awareness.
Yes, and as we said, one of the bigger challenges has been the fact that not many people know about this law. And the other thing that I've been seeing from doing different tabling events and that people will come up to the table and you can clearly see that they're very upset that they've experienced this where they feel like they have been denied housing because of their background, and we would exchange information and everything, and then a lot of times they would just not follow up, and I always found that kind of odd because we would have this discussion and you can tell that they was like really affected by this. And then we want to help, we would love to help. And a lot of times it's just not any follow back. They don't follow back up. I would call, reach out to them. And so that's the thing that I'm really trying to figure out ways how we can like make sure that this process is followed all the way through and that we can provide them with the assistance that they need, if there's anything at all that we can do. But that's one of the bigger challenges that I've been seeing is just one, people not knowing about this law, and two, I don't know if just having people actually come to us so we can assist them. So
Yeah. And then I think that was our
I
last
would turn it back over
content.
to Ashley.
Yeah, I think that was our last bit of content on our slide. So I think it looks like we have a little under 5 minutes for any questions. I've also put our contact information on the slide. Please, feel free to reach out. I can also put our emails directly into the chat. So yeah, I'll just like open it up for any questions.
Actually,
I also,
I had a
yeah,
question,
please.
Ashley, if I could. I had thought that, and Reese too, I had thought in Cook County that there actually are some openings if someone is convicted of a sex offense. I don't recall, when I say openings, it's not ironclad that I understand the process, but I thought there are still a possibility that certain landlords, there's some flexibility there depending on certain facts. I don't know. You might want to speak to that, or am I wrong?
Yeah, so that's excellent question. And kind of, I mean, there are always landlords. Some of them are not as good as others, but there are landlords. There's nothing prohibiting landlords from allowing people who have to register for sex offenses from becoming tenants. A lot of them don't want to, which is what the JHA would help with. But unfortunately, the JHA, that is an explicit carve out, is just people who have to register for sex offenses. And then I'll also address Mike's comment, which is very accurate, and I completely agree with you that the very, very narrow slice of people who don't have to register based on their conviction is very small and not very helpful of a distinction. And I mean, I think I'll hop on my soapbox here and say that, I mean, it is a political decision that whoever the coalition decided to make because of the stigma around people who have to register based on sex offenses. And because the logic of the JHA is great in some respects, because it's saying that people who have already done their time, they've already been released, they shouldn't be further punished by finding these barriers to housing. And that's great. But then unfortunately, the way that it's written is that limit is the people who are on the sex offense registry, which just doesn't make any logical sense. But I mean,
what is the process again, though? I'm trying to remember. I thought there was a process where that gave an opening to those with a sex offense in terms of how the application process works. Can you remind us of the? Now,
sure.
And by the way, everyone should know that I'm speaking just to Cook County. It's a very narrow subset of where people would be looking for housing, I understand. But I know we have certain individuals participating tonight who have an interest in Cook County. And then
Yeah.
I'd also like you to speak for a moment, unless you have already, because I stepped out briefly, to other states of what you see in terms of movement there, if you could.
Yeah, so I'll address the other states question first, which is I did talk about it briefly, but there's the slides, and I'm happy to have those slides be circulated among everyone if there are any follow-up questions about the states. But we are seeing some general trends about how these states are structuring these kinds of laws, and a lot of them are very similar to the Just Housing Amendment. So hopefully this is a helpful model for understanding other states. And then for your to your other question, David, about the opening, I agree. I think there is the way that you've put it. So here's how I guess I'll walk through it. Even if someone has a sex offense, the landlord should still not ask them at the beginning stage if they have any felony convictions. So theoretically, this person with a sex offense should have to go through the same process and the way that it's structured, where they are pre-qualified first, and then they do the background check.
Right.
The issue is, though, so, if they are a stellar, applicant, there is a chance that a landlord is like, you know what, I'll give this person a shot. The problem, I think, is that if the landlord does see the background check, sees a
Right.
sex offense on it, and rejects them, there's no recourse, unfortunately, like there would be with other convictions. But it does let them get a foot in the door. I'm just, I'm doing the lawyer thing of like kind of being pessimistic about
Yeah, it's
people.
not a categorical denial at the start.
Exactly.
It's a practical matter once you get
Exactly.
to the next step, right?
Yeah. But it does, I think, the way that the JHA is structured and the way that it is supposed to be followed does allow people to get the foot in the door. And something that I've heard, I haven't necessarily seen this, but the rumor around Cook County is that a lot of landlords are just like, I don't want to even mess with a background check. And so some of them are dropping it entirely, which could be beneficial.
And are you seeing any movement in any of the other counties?
I could not speak to that, unfortunately. No idea. I hope so. Okay. Mike, yeah.
Yeah, thank you. Superb presentation.
Thank you.
If I lived in your city, your county, your state, I would definitely take you guys on as advocates. I'm very impressed by your knowledge, your succinctness, your articulateness. So I live in Pennsylvania and in Philadelphia. I'm on federal supervisor lease. And what I've noticed in just my readings and my exposure to this issue is that you have a conflict between different ends of the law. So on the one hand, you have politicians who make these very restrictive laws having to do with the registry and the distance from which you can live to a park or something. And then you have the people tasked with enforcing those laws, for example, probation and parole agents, whose primary goal is to have the people under their sway be housed and therefore be accountable. The counterexample, the ultimate counterexample is the state of Florida, where there's still major problems, but at one point, I think 60 Minutes did a whole thing on groups of well over 100 living under I-95 due to the housing restrictions. Well, if you're a probation or parole agent in Florida who was in charge of people with sex offenses, that's a nightmare situation for you. The reason I'm bringing all this up is I'm wondering is if you guys have any collaboration, not collaboration, but like, communication with law enforcement agents with such tasks whereby they can express their frustrations. And if that can be a feedback loop into the process, perhaps alleviating such, extraordinarily harsh conditions.
Yeah, you've articulated the just pointless, like, cruelty of that whole system very, very well. And the answer is yes, sort of. We at UPLC don't, but our colleagues at the Chicago 400, they're actually sponsoring a bill in the Illinois state legislature to mitigate some of the effects of these really restrictive banishment laws is what they call them. And one of the bills, and I unfortunately can't remember the name off the top of my head, but again, I'm happy to circulate this later if folks are interested, actually has the support of some of the police, because they're like, this is a waste of our resources. This is a waste of, it's not keeping anyone safer. It is just pointless administrative work. I think the requirement that people who are unhoused and who are also in a registry have to register every week, which is just makes it impossible to hold down a job, makes it impossible to have like a steady housing. So it's just not, and it's a waste of everyone's time. So it was really interesting to me, and interesting that you identified that, Mike. They were able to get some kind of police rep group on board with this to say, like, look, this is actually, you should vote for this because it's a waste of our time, and this is going to be an improvement of policy.
Thank you so much for the answer. And I just wanted to also thank Mr. Hughes for your appearance and for your your lived experience, and for your superb role in helping people in the community, where there's such need. Thank you.
Other questions?
Well, I have some potential good news. On the heels of the webinar a couple weeks ago, I reached out to Michael and Adele, and I wanted to know if they would be willing to work with some of us in leadership at the American Bar Association to put together a resolution attacking the overbreadth of these residency requirements for sexually oriented offenders. And they said they would be willing, and some of the other members of leadership are enthusiastic about it. I particularly appreciated Ashley's point about law enforcement being supportive of decreasing these restrictions, because we do have a very strong law enforcement section within the American Bar Association, and their support of such a resolution could really be crucial.
Any comments, Ashley or Reese, on that? Or
I just want to touch on that a little bit too. Something that Mike had brought up as well. Like the parole agencies, I know that there was some type of initiative, at least prior to me being released, but I benefited from it. I seen once I came home, where they were trying to like dial some of these things back to make parole not so strenuous and hard for individuals to get through. And I definitely feel that they have done that, because like I say, I can say for myself, I actually was I got off of parole early, even though Illinois don't have parole. MSR, I'm gonna say, I got off of MSR early because of those changes that they've made. So I do agree that I think that it would make sense for the parole agency as well as law enforcement to get behind some of these things, because their caseloads for the parole officers anyway, it was just so ridiculous that I think things like this is only making it worse. It's just compounding that issue by making it hard for individuals to find housing. So I agree with you, Mike, on that. There should be some type of collaborative effort between parole agencies and law enforcement to kind of try to help change some of these restrictions.
Thank you so much, Mr. Hughes.
Well, not only that, this is Michael speaking. Not only that, it just makes good common sense to make sure that people are housed, especially ex-offenders, all ex-offenders, because being homeless subjects a person to a level of degradation where drug abuse and drug addiction is rampant. And when you force a person into a situation of homelessness, there's a large association with despair and a feeling of hopelessness. So, in my opinion, if you take an offender, or we'll talk about sex offenders because they've been marginalized, that makes it a very dangerous person. I mean, this person, you've subjugated them to living outdoors under a bridge, for God's sakes, and you've taken away their hope, you've taken away their dignity, And it's kind of counterintuitive to the legal justice system, in my opinion. If you say that you're trying to rehabilitate people and you send them to a period of incarceration and they serve that period of incarceration, and then you subjugate them when they come out of prison, and you continue to punish them, you continue to compile restrictions on them, that's not the way the legal justice system is supposed to operate. And also, in my opinion, I feel that these lawyers, I mean, you got to love them, but these lawyers, some of them, a lot of them are afraid to tackle the issues, especially when it involves sex offenders, because of, maybe committing political suicide if something were to go awry. And when you help a population like that, things do have a tendency to go awry. You can have 900 people that are a success story, and you're always remembered by that one failure. So I applaud the efforts that you guys are doing in trying to secure housing for people. And I understand that it's an uphill battle, but it's something that really needs to be tackled. And you guys are just doing a wonderful job, and I applaud you. Thank you so much.
Thanks, Michael. Matt Schaefer has been waiting patiently.
Yes, ma'am.
Excuse me, just for a second.
No, I'm sorry. Svetlana,
Excuse me.
Matt's going to reply. Sorry, Ashley.
Yeah, I was just going to thank Matthew. Thank you for sharing all of that. That's really very helpful context. And yeah, I'm making a note to myself to try and circulate some of the materials from the Chicago 400 on their state level advocacy, because I know this is not going to address directly any of the stuff that you brought up, Matthew, but I know one of the things that they're trying to advocate for to mitigate this issue is to reduce some of like the restrictions about being near schools, the length, because like if they have this wonderful map of Chicago. I say wonderful because it's like very visually effective, but it just shows how few places there actually are that are an option for people in the city of Chicago and Cook County, that aren't like too close to a school or aren't too close to a park. So I know that's something that they're working on. But yeah, I mean, to your point completely, I agree. I think the JHA is about giving people a fair chance. And I mentioned that already, that I think that is the part where it falls short, that it kind of doesn't follow logically that everybody else gets a fair chance except for this carve out of people. And at the very, very least, there should be, an opportunity to have your application be evaluated away from that registry requirement or conviction, so that at least it's on the same footing as everyone else. So I will look into that. I really thank you so much for bringing that up. I'll talk to some of our policy friends and see if any possibilities there are to try and make that a reality.
Comments or questions for our presenters today, please.
That's it then? Okay. Michael, anything further?
Well, I'd just like to really thank everyone for being here, for showing up on a weekend night when you may have work tomorrow or other responsibilities in your lives, making time. I'd really like to thank especially the presenters for their superb handle on this complex and somewhat maddening issue that's got so many different inputs that are in conflict, even when ostensibly well-intended. So having people to fight that fight for the people who have no voices, as Mr. Hughes said, that it's very easy. And as Michael said, to get down in the dumps, that when you have so many things against you, to have people like you, providing such a service, providing such information, such advocacy is extra important. So thank you so much for doing that and for being here tonight to share with our audience what you're doing.
Thank you so much for having us. We really, really appreciate this opportunity. And I think I can speak on behalf of both of us when we say we hope that this is not just, a one-time conversation. Please stay in touch with us. We hope to, continue talking about this and, working alongside all of you and sharing information and resources. We've had a wonderful time, and thank you again for hosting us.
And I'd like to thank you both as well, Ashley and Reese, and I'd like to say on behalf of Alan as well. Alan's been a multiple year participant. We'd like to have both of you back next year to discuss further developments, further progress, and I'm sure everybody here would be very happy to have you. We're thrilled that you could join us tonight. Thank you. I want to specifically say to all of you, all of our participants this evening and throughout the course, how much I'm so thankful that all of you could continually come and, as Michael said, participate on evenings when you, I'm sure, have other things that you could certainly be doing. We hope that the topics that we've discussed throughout all of these courses have been worthwhile from your point of view and helpful. We're all available, as Alan and Elizabeth and Ashley and Reese had said all along. If you would like to discuss any issue with any of us offline, please feel free to reach out, and we'd be helpful in every way that we can. And I think we're all aligned in saying that we're very proud to be a part of the HINDA family, and we will continue to work forward to provide helpful information to all of you and on an ongoing basis. And we look forward to seeing all of you in next year's legal panel for 2025. Thank you. Thank you all so much for joining us tonight. Michael or Carlene, any final comment? Or
I don't know if Carlene is here.
okay.
But I also would like to give a thanks to Mr. Soon to be Dr. Buslick, or maybe you are a doctor already. If I made that mistake, excuse me. And also to Ms. Kelly, who, so between you guys, you have, Illinois, Greater Chicago Metro, and the international space. We have all the ground covered, guys. Very impressive that we have you here with us. So that really helps add to the conversation, your particularistic and your general knowledge and practice. Thank you.
Thank you.
Good night.
Thank you.
Good night, everyone.
Good night.
Thank you so
Good
much.
night.
Have a great evening.